In a significant setback for the proposed Kroger Albertsons merger, a Colorado judge has issued a temporary restraining order, halting the deal's progress. This unexpected development has sent ripples through the grocery industry, leaving many to wonder about the future of this mega merger. The proposed merger between Kroger and Albertsons, announced in October 2022, sent shockwaves through the grocery industry. The $24.6 billion deal would create a retail giant, combining the nation's two largest supermarket chains. With over 5,000 stores across the United States, the combined entity would rival Walmart in scale and market presence. The merger was seen by proponents as a strategic move to compete more effectively in an increasingly competitive grocery landscape. The rise of online grocery delivery services like Amazon Fresh and Instacart, along with discount retailers expanding their grocery offerings, has put pressure on traditional supermarkets to adapt. By joining forces, Kroger and Albertsons aim to leverage their combined resources, streamline operations, and enhance their digital capabilities. They argued that the merger would allow them to offer lower prices, a wider selection of products, and a more convenient shopping experience for customers. However, the proposed merger immediately faced scrutiny from regulators and lawmakers concerned about the potential consequences of such a massive consolidation in the grocery industry. From the outset, the proposed Kroger-Albertsons merger raised antitrust concerns. Critics, including consumer advocacy groups and competing grocery chains, argued that the deal would stifle competition and harm consumers. They feared that the combined company would hold an excessive market share in many regions, giving it the power to raise prices, reduce product selection, and potentially force smaller competitors out of business. State attorneys general, including those from Colorado, California, and Washington, launched investigations to assess the merger's potential impact on competition and consumers. These investigations focused on areas where Kroger and Albertsons operate stores in close proximity, raising concerns about reduced consumer choice and the potential for price hikes. Additionally, labor unions representing grocery workers expressed concerns about the merger's impact on jobs and wages. They feared that store closures and layoffs could result from the consolidation. These concerns added another layer of complexity to the regulatory scrutiny surrounding the deal. Section 4. Divesting to compete the C&S wholesale grocers deal. In an attempt to alleviate antitrust concerns, Kroger and Albertsons announced an agreement to sell a significant portion of their stores to C&S wholesale grocers. This divestiture, a common strategy in mergers facing regulatory hurdles, aimed to create a more competitive landscape by empowering another player in the grocery market. Under the agreement, C&S wholesale grocers would acquire up to 413 stores in 17 states and the District of Columbia. The deal also included 8 distribution centers, 2 offices, and private label brands. This divestiture package was designed to create a viable competitor that could challenge the dominance of the merged Kroger-Albertsons entity. The divestiture agreement with C&S wholesale grocers was seen as a crucial step in addressing regulatory concerns and potentially securing approval for the merger. However, it remained to be seen whether this move would be sufficient to satisfy regulators and alleviate concerns about the merger's impact on competition and consumers. Section 5. The price of approval, financial implications of the amended agreement. The amended agreement with C&S wholesale grocers, while intended to address antitrust concerns, came with a hefty price tag for Kroger and Albertsons. The divestiture of hundreds of stores and other assets would inevitably impact the financial profile of the merged entity. Analysts estimated that the divestiture package could reduce the combined company's annual revenue by billions of dollars. This reduction in scale could affect the merged entity's purchasing power with suppliers, potentially limiting its ability to offer competitive prices to consumers. Moreover, the costs associated with the divestiture process, including legal and administrative fees, would further impact the financial performance of the merged company. These financial implications added another layer of complexity to the already intricate merger process.